So good afternoon, everybody. I'm delighted to welcome you all to the first edition of the PM Mukhi Memorial Human Rights Lecture. I welcome the speaker, Justice Dhananjay Y. Chandrachud, Supreme Court of India, and thank him for taking time from his busy schedule to be with us today and deliver this lecture. I will introduce him to you all in a few minutes. This lecture series has been instituted in memory of my late father, Parsuram M. Mukhi, and I'd like to welcome the audience members, including members of the extended Mukhi family who have joined, some of them from all over the world, personal friends and associates, including many who knew my late father, and the IISER Pune community. I'm particularly happy that I could make this event open to IISER Pune students, a vibrant lot who have made my decade at IISER a real pleasure. I hope that attending lectures about human rights will influence your future thoughts and deeds when you yourselves become leaders. The first three speakers in this series were Vivek Diwan, Pratap Bhanu Mehta, and Usha Ramnathan. These three lectures were held physically on the premises of IISER Pune. I also want at this stage to thank my new colleague, Professor Ashish Arora, for his help in organizing this lecture and providing the link on which we are holding it. At this stage, I have a sad duty to perform. I would like to dedicate this year's lecture also to the memory of my brother, Anil Mukhi, who passed away just 3 months ago. He lived in Canada and had personally attended the last PM Mukhi Memorial Lecture in IISER Pune in January 2020. We tragically lost him very recently due to a serious illness. His absence is deeply felt, but his spirit is still with us. Let me now say a few words about my father. In the past, I did not want to go into details about him during the events that were held at IISER, but today I feel that I can and I should do so. My father was born in Hyderabad, Sindh, in undivided India, and migrated first to Delhi and then Bombay with my mother after partition in 1947. A wonderful thing about both my parents was that they did not harbor any resentment against people of any religion, despite being essentially forced to flee their homeland. They saw the problems that they and others were facing as being essentially political in nature and did not feel ordinary people were to blame. They always spoke warmly and with nostalgia about the many kind neighbors and friends who they left behind in Karachi and in Hyderabad, Sindh. They settled in Bombay in the early 1950s, and I will skip the biographical details about my father from that time for the rest of his career, except to say a few things which are essential. He worked as a lawyer in Bombay throughout the 1950s and 1960s. In 1972, he became a judge of the High Court of Bombay, where he worked for 4 years until his untimely passing in 1976 at the age of just 58. During the first three memorial lectures held at IISER, I spoke about my father with these words, which you see on the screen: a strong supporter of rational discourse on social issues, of the rights of individuals, and of the need to uphold and protect the legitimate aspirations of human beings from the pressures of powerful organizations, both public and private. These are my words. This was my perception about him. But to bring him to life a little more, I will like to quote the words of my father's brother, Jay Mukhi, also a lawyer, who passed away just a year ago. He outlived my father by about 45 years. He wrote an obituary article about my father in the Indian Express in 1976, from which I will read. This might bring my father a little bit more to life for all of you and tell you a little bit more about what he was like. So here is the quote. He was unable to understand why people did not think logically. He thought in straight lines, no corners, no rounding off of the edges, no ulterior motive, no desire to flatter or please. A spade was a spade. This, of course, made him unpopular with quite a few. It was thus that those who liked him did so in spite of the bitter pills that he administered and for his deeper qualities. The friends who surrounded him and kept with him till the end were, without exception, genuine parties. They liked him for what he was, a simple, well-meaning man, compassionate by nature, and generous with his time and talk. He was intensely emotional and a very great helper. His heart bled for the underdog. He never gave thought to the consequences of doing justice. So this is the quote from the obituary written by my father's brother, whose son actually is with us today at this talk. Now, moving on, during the 1960s, my parents became good friends with Yashwant and Prabha Chandrachud, the parents of today's speaker. Justice Yashwant Chandrachud, roughly the same age as my father within a couple of years, was a judge of the Bombay High Court from 1961 to 72, after which he was elevated to the Supreme Court. In 1978, he became Chief Justice of India and held the post till his retirement in 1985, making him, I believe, the longest serving Chief Justice of India ever. When my father became a judge in 1972, he even quoted his dear friend Justice Chandrachud, Sr., in his reference speech, of which I am fortunate to have a copy. On a personal note, I recall meeting the family several times. The last of these was probably in 1972 when I was 16, after which they moved to Delhi. On many of these occasions, I also met their son Dhananjay, 3 years younger than me. Mrs. Prabha Chandrachud, who was Dhananjay's mother, who was a Hindustani classical musician, actually played a far-reaching role in my life, and I think it will be nice to share that with you. In 1968, at the age of 12, I declared that I wanted to learn to play the sitar. And I told this to my parents, and my mother naturally turned to Prabhaji for help. She took us to a shop and helped us buy what became my first sitar, on which I took regular lessons for 8 years. This kindled a lifelong involvement with music. This brings me to our speaker today. Justice Dhananjay Chandrachud studied law at Delhi University and Harvard. After graduating, he worked at the US law firm Sullivan & Cromwell, then returned to India to practice law at the Bombay High Court and the Supreme Court of India. In 2000, he became a judge at the Bombay High Court and subsequently moved to Allahabad, where he was elevated as Chief Justice for a few years from 2013 to 16, and then to the Supreme Court of India. There he is a member of the Collegium, which is the group of 5 senior-most judges, which are tasked with some very important decisions. Though we have not met for half a century, I followed some of his judgments as I have a little interest in law. In particular, on August 24, 2017, a 9-judge bench of the Supreme Court delivered a landmark judgment on the right to privacy, known as the Puttaswamy case. At the request of my colleague, Professor Shashidhara at IISER Pune, I skimmed through the 547-page judgment and gave an hour-long talk on it at IISER Pune for the students. 266 pages of this judgment were written by Justice Dhananjay Chandrachud and co-signed by 3 other judges. The remaining judges wrote somewhat shorter judgments of their own, broadly in agreement with this. I would like to quote a small part of this particular judgment from the 266 pages. The refrain that the poor need no civil and political rights and are concerned only with economic well-being has been utilized through history to wreak the most egregious violations of human rights. Above all, it must be realized that it is the right to question, the right to scrutinize, and the right to dissent, which enables an informed citizenry to scrutinize the actions of government. Those who are governed are entitled to question those who govern about the discharge of their constitutional duties, including in the provision of socio-economic welfare benefits. The power to scrutinize and to reason enables the citizens of a democratic polity to make informed decisions on basic issues which govern their rights. The theory that civil and political rights are subservient to socio-economic rights has been urged in the past and has been categorically rejected in the course of constitutional adjudication by this court. This is the end of the quote that I'm reading out. Back to people. So for years, I was hesitant to contact Justice Chandrachud regarding this lecture, largely because we had not met for so long and I wasn't even sure he would remember me. But I finally did so in late 2021, and I got a reply from him from which I quote, "Your letter brought such warm memories of the abiding friendship between our parents. I have vivid memories of visiting your home on numerous occasions in Mumbai as a child with my parents. It will be an honor to deliver the lecture. I am really happy, delighted that this has finally come to fruition, and I request Justice Chandrachud to please deliver the 4th PM Mukhi Memorial Human Rights Lecture. Unfortunately, due to the online nature, there will be no questions for today's talk, but I hope the speaker will visit ISER Pune someday and engage with us more informally. With that, I stop sharing my screen and it's over to you. You have to unmute yourself before starting. Still muted. Yeah, good.
Good evening, and thank you very much for this warm introduction. I'm delighted to be here. Very good evening to everyone, including the members of the family of Justice Mukhi. It is my honor to today deliver the Justice PM Mukhi Memorial Lecture in the memory of late Justice Parsuram Mukhi of the Bombay High Court. I thank his son, Professor Sunil Mukhi, for having invited me to deliver this lecture. The association between our families goes back a long way. Professor Mukhi's parents, Parsa and Sadla, as they were to my parents, shared a long association. They were connoisseurs of Western classical music, heard on the gramophone on long playing records before the advent of cassette players and the modern digital age. My parents belonged to the genre of traditional Maharashtrian families from Pune and loved to listen to and sing Indian classical music. The food on the Mukhi dining table was a novelty to us. Mushrooms and paneer were unknown entities in our home. My parents, and through them, I, as a little child, were introduced to their eclectic tastes in music, food, and culture. This perhaps was my first engagement with a world view of life. A Diwali evening was spent happily on the terrace of Sunil Mukhi's apartment building on Mount Pleasant Road in Mumbai. The story of Justice Mukhi's life is an inspiration in itself. After having been a civil judge in the Sindh region of Pakistan, he moved to Bombay during the horrors of partition. Never one to let his circumstances bring him down, Justice Mukhi then restarted his legal career in Bombay, as it was then known. In the years to come, he made a name for himself as a litigator and was then appointed as a judge of the Bombay High Court in 1972. While his time on the bench of the Bombay High Court was limited, his judgments aimed at delivering justice to all members of society. During the internal emergency of 1975, Justice Mukhi was unfortunately transferred to the Calcutta High Court since he spoke out against the then government's draconian measures. Sadly, it was in the Calcutta High Court that Justice Mukhi soon passed away. What then was a tragic departure from a life so well lived has since become a badge of honor for judicial independence. His memories and sense of justice still linger with all of us who knew him and who share his commitment to use the law as a tool to help the less fortunate. During his reference speech when he became a judge of the Bombay High Court, Justice Mukhi quoted my late father, Chief Justice Y.V. Chandrachud, and said, "The cause of justice can only be helped by our participation. I believe that if the lawyer and the judge can work together as a team, then many of the defects in the system as it exists today can be overcome. The material is there. We have only to work with." Through my lecture today, I hope I can do my part in honoring Justice Mukhi's legacy. Today, I intend to address you, the students, faculty, alumni of the Indian Institute of Science, Education and Research, and the guests on a topic that invites and unites our seemingly disparate vocations, law and scientific advancement through technology. Through my lecture, I will attempt to demystify the relationship between law and technology. Traditionally, it is assumed that law and technology will be at odds with each other, with the law favoring the protection of rights, while technology aims to foster innovation. However, today I posit that law and technology have an interconnected relationship which can achieve both the protection of individual rights and the promotion of innovation in our society. Let me begin by remembering the words of the noted science fiction author A.G. Wells in his last book titled Mind at the End of Its Tether, where he famously claimed that we, as in us humans, live in reference to past experience and not to future events, however inevitable. While his own intentions and contexts were slightly different, I keep going back to this quote as I begin thinking about our discussion today. People always assume the relationship between law and technology is one where the law is invested in curbing technology. Possibly this is because of the presumption that a discipline that relies on history and precedents will never understand, much less facilitate, a world that constantly seeks to reimagine the future. I find this presumption peculiar because the legal discourse has always found immense value in using technology. If you think about it, the legal discipline is rooted in documentation. In that regard, the very origins of computing have benefited the legal fraternity as much as anyone else. In fact, technology companies in the United States began targeting law firms since the invention of a phonographer voice recorder in the early 1950s. Likewise, the legal sector was revolutionized with the introduction of the red Ubik terminal, an early model of a computer that enabled lawyers to access case law online. The word processor, the fax machine, the personal computer, cloud computing, and now blockchain technology have all played a major role in the evolution of how law is practiced around the world. It was only a few years back that Catherine Hahn, a federal prosecutor in the United States, made use of the permanent nature of a blockchain trail to indict federal agents who had stolen bitcoins worth millions of dollars. Thus, legal discipline has never shied away from technological innovation and its application. Yet, the presumption still exists. Now, one could argue that this premise has less to do with how technology is used by a few tech-savvy law firms, and much more to do with how governments, bureaucrats, and courtrooms approach this discussion. Even there, however, I believe that the relationship between law, governance, and technology has often been considered to be one of complementarity. Let me explain this by considering the impact of one such technological change, that being the advent of the internet age on legal rights and structures of governance. To begin, it is often argued that the internet is a crucial tool which has vastly improved the work and relevance of the numerous human rights organizations which monitor human rights violations. In 1994, the Freedom Forum's Media Studies Center noted that there appears to be a quality of inevitability to the marriage of a democratizing technology such as the internet with the world of humanitarian and human rights activities. Other scholars have similarly discussed how the internet can assist human rights organizations across the globe by improving the means of transmitting information in four ways: through increased speed, at reduced cost, with a wider scope, and all the while allowing for greater interactivity. It is believed that this will allow the human rights organizations to more effectively record instances of human rights violations, which will provide for necessary evidence in persecuting those who commit such crimes. Similarly, the impact of the internet on an individual's right to freedom of speech has also been substantial and meaningful. In her seminal article in 1998, Kathleen Sullivan, a leading constitutional law scholar in the United States, has noted that it is tempting to see the internet like First Amendment manna from heaven, where the First Amendment to the United States Constitution is their guarantee of the right to the freedom of speech, which furnishes technological and organizational preconditions for considerable equality and competitiveness among speakers, and accordingly, for an abundance of speech. Since a statement in 1998, it has been widely accepted that the influx of the internet age has democratized speech for all individuals. Traditionally, government has controlled the platforms through which individuals could make their speech heard to others. However, with the advent of the internet and social media, individuals can now directly be in control of these platforms. An important example of this is during the Egyptian revolution of 2011, where social media platforms were widely used by protesters to organize protests and to communicate with the outside world in order to highlight the human rights violations being committed by their government. In fact, global institutions such as the United Nations and Human Rights Council and courts such as the European Court of Human Rights and the Inter-American Court of Human Rights have all categorically held that an individual's right to freedom of speech and expression can be exercised through the internet. Even in India, the Supreme Court has recognized a citizen's fundamental right to speak, express, and receive information through the medium of the internet. An individual's right to privacy on the internet has similarly been upheld by numerous global institutions and courts. Crucially, they all accept that without the guarantee of privacy on the internet, an individual's right to health, education, freedom of movement, freedom of peaceable assembly and association, and freedom of expression will be compromised. In India, in the case of Justice K.S. Puttaswamy versus Union of India, a bench of 9 judges, including myself, held that the right to privacy is a fundamental right inherent in the Constitution. My reasoning was that reading the right to privacy as a fundamental right is imperative for the Constitution to protect our people in the digital age, where individual digital identities are equally important as their identities in the physical world. The onset of the internet age has also helped democratize elections by allowing candidates to harness the power of social media to reach out to their electorate easily and without spending great amounts. It has also created avenues for information to be shared more freely, which is useful for preventing voter fraud and for creating more awareness amongst individuals about their right to vote. Till now, I have spoken of the impact of the internet on our most crucial constitutional rights. But judges like me are constantly called upon to interpret rights and obligations that are mediated by technology, not only in a constitutional sense, but even in seemingly routine functions. Hence, it is crucial for us to remain abreast with emerging technologies and their application to our existing systems. Recently, I had to adjudicate upon the applicability of revised tariffs under the Customs Act, which had been digitally notified on the internet, thereby rendering the timing of when the law came into effect and the bill of entry was submitted to be determined with precision. I also believe that the use of technology and the internet has not only expanded the scope of an individual's rights, but also their access to basic services that better help them realize these rights and liberties. Recently, we have been witnessing an increased reliance on information communication technology by the union and the state governments for creating initiatives to improve governance, provide public services, and strengthen accountability mechanisms. For instance, the Digital India program of the Government of India aims to achieve inclusive growth by transforming India into a digitally empowered society and knowledge economy. Similarly, on the part of the Indian judiciary, there has also been an integration of technology and justice. As early as 2004, the Supreme Court of India established an e-committee to adapt the administrative reforms in the judiciary to the information technology revolution. Since 2017, I have been serving as chairperson of the e-committee, and I have gained valuable insights on how technology can really, in that sense, be made an enabler. Now, on the part of the judiciary, it is important for us to understand that the Indian legal system is currently steadfast on its path towards digitization due to the work of all the dedicated members of the e-committee, including Justice R.C. Savan, who has joined us online. We have sought to make a one-stop portal for the judiciary in India through the National Judicial Data Grid, a repository of metadata holding court records of 40.3 million pending cases. This data also ensures greater transparency and accountability of our courts. Further, technology has not just been used as a facilitator for existing judicial processes, but has also been used to transform the citizens' experience of the judicial process. For instance, the traffic courts dealing with ordinary traffic violations have received a substantial boost with the introduction of automated settlement processes, which allow persons to pay their dues without grappling with litigation. Surprisingly, the COVID-19 pandemic proved to be a spectacular accelerant to the virtual and digital courts project in India. Once the lockdown was imposed in 2020, the Supreme Court of India started conducting virtual hearings from the 23rd of March. In the beginning, we had to mitigate the technological barriers that litigants faced in accessing justice. At the same time, there was a fear that the pandemic would increase the backlog of cases. Thus, the immediate challenge at hand was to create a robust, technology-enabled system that could effectively deal with fresh litigation and concurrently prioritize pending cases. Crucially, we had to ensure that the closing of the precincts of the highest constitutional court of the country did not mean that the doors of access to justice were closed. We had to perform our duty to protect civil liberties, attend to cases of public importance, and be available as the court of last resort. Slowly, the virtual court systems were also adopted by all courts across India. The cause of justice could not have been brought to a standstill due to the pandemic. Several courts, including many among the district courts with little or no infrastructure or experience with virtual systems, stood up to the task and are now making a transition to permanent avenues of hybrid hearing models. The e-committee's e-courts project, which has been in its second phase since 2015, played an instrumental role in creating a technology-enabled judicial system that could withstand the novel challenges of the pandemic. Through the e-courts project, we managed to create a system that was conducive for virtual courts, electronic filings, and online payments. Let me give you a snapshot of what the e-courts project was able to achieve in the past year. First, 3.54 billion electronic transactions were undertaken under the e-courts project, which highlights the sheer reach of e-court services to the common citizens. Second, a total of 19.6 million cases were heard by courts through video conferencing. Third, out of the 13 million cases registered in Indian courts over this period, 8.3 million cases were disposed of, thus achieving a disposal rate of over 60%. Finally, in our endeavor to promote paperless filing, we also developed an e-filing software using which over 100,000 cases have been filed online in over 17,000 district courts and 25 different high courts in India. I truly believe that the silver lining of the COVID-19 pandemic has been the nudge faced by judges and lawyers to adapt to technology in their work in the legal ecosystem. During the virtual hearings, I have personally observed several lawyers and evidently new mothers arguing from the safety of their homes. This was a welcome change from the past, where women were unfairly forced to take a step back in their careers or steer away from barrister practice altogether, owing to its harsh and often gender demands. A digital mode of e-filing and e-courts also has the potential to address several of the iniquities that are entrenched in the existing systems that hitherto served only the able-bodied. Technology is a great enabler in enhancing access to justice. On a personal note, I have taken this time to build on my technological skills and now exclusively rely on my laptop for all court-related matters. Journalists who cover the beat of the Supreme Court of India access the Supreme Court online through the links which are provided to them as to lawyers. Another necessary and welcome byproduct of the transition to a virtual ecosystem was the increase in public access to our judicial systems. At the E-Committee, we saw this as an opportunity that could serve the cause of open justice. Live streaming was introduced in high courts based on the model rules framed by the E-Committee. The high courts of Gujarat, Karnataka, and Orissa have begun live streaming court proceedings in the Chief Justice's Court. This is an attempt to demystify judicial processes, increase judicial accountability, and disseminate information in cases of public importance. Through the whole experience of the COVID-19 pandemic and the transition to virtual ecosystems, I understood that technology can tremendously empower, but only if our institutions are designed to enable such empowerment. Sadly, at the heart of the wonderful overnight transition to virtual courts during the pandemic also lies the unembellished fact that there exists a digital divide in the country. The widespread shift to virtual platforms exposed the deep fissures in our society on access to the internet. It showed us that not everyone can afford to work or study from home when high-speed internet, gadgets, and even something as basic as electricity are not publicly guaranteed utilities. The E-Committee and the E-Courts project have been cognizant of the inherent inequalities that exist in our society and how they stand to get reinforced with the switch being made to a virtual ecosystem. Hence, we created service centers that could consolidate all the essential facilities offered under the project and make them available to litigants who lack digital access. These facilities include providing soft copies of judicial orders, facilitating e-filing of petitions, appending digital signatures, facilitating e-payments, and guiding people on availing free legal services from legal aid authorities. We have also ensured that our online judicial processes protect the privacy of our litigants and provide data security. As a part of the E-Courts project, we also took steps to make our digital services accessible to persons with disabilities by adhering to the principle of reasonable accommodation. We are also currently in the process of digitizing over 31 billion court records across India. Presently, we have launched this digitization project in 5 high courts as a pilot. The standardization of digitization across the country will ensure interoperability between data repositories and is bound to make our justice delivery system more seamless and efficient. Digitization of court records will also expedite the dispute resolution process and particularly, it will advance the objective of an efficient enforcement of contracts as sought to be achieved by our commercial courts. This will also improve the ease of doing business in India in terms of the guidelines which have been issued by the World Bank. Another crucial lesson that the transition to virtual courts taught me is that digital reform should not be limited to merely automating our old ways of working and transposing the old physical infrastructures to a virtual environment. As Professor Richard Susskind argues, the COVID-19 pandemic has given us a springboard into a new world, but right now we are just at its foothills. While I believe that this is what the future should hold for us, transitions must be accompanied by a vision of access and inclusion. We have a long road ahead towards ensuring that technology can be meaningfully adopted in order to ensure greater access. This can only be achieved by democratic processes that are concerted in their aim to progress, but with an equal aim of leaving no person behind. To achieve this goal, the legal fraternity will have to work hand in hand with our scientific community, which is the relevance of my discussion and talk today. Thus, we can now understand how internet and technology have revolutionized the scope of our rights and our interactions with the government and the judiciary. The nature of efficiency and convenience which arise from the solutions in the digital age marks a profound shift from life just 2 decades ago. However, let us remember that all solutions come with a cost. I was reading The Age of Surveillance Capitalism by Shoshana Zuboff, and she begins the work by saying and asking a question: are we all going to be working for a smart machine, or will we have smart people around the machine? The first kind of price that we seem to be paying is through digital profiling of all persons. Every transaction of ours and every site that we visit leaves electronic tracks, generally without our knowledge. These electronic tracks contain powerful means of information which provide knowledge of the sort of person that the user is and their interests. All of this data needs to be protected. In aggregation, this data may disclose the nature of an individual's personality, food habits, language, health, hobbies, sexual preferences, friendships, ways of dress, and political affiliation. Privacy concerns are a serious issue in the information age, and our laws must evolve to address them. The second kind of price is the nature of changes in our society due to the vast amount of information available through the internet. Characterized by scholars as an attention economy, all of us today are overwhelmed with the information we find online. This can have negative effects in multiple aspects of our lives. We can become susceptible to false information. We may be unable to verify the truth, or the information we receive may just become what is dictated by an algorithm without any real choice on our part. The vastness of this information can also have a numbing effect, where we become so used to hearing about issues that they no longer even affect us. Long back in 1996, a scholar eerily predicted that in an information age where satellite television broadcasts and internet appeals to address mass violations of human rights reach world populations on a daily basis, there is a danger that people will become callous to reports of difficulties everywhere in the world, that the limited human capacity for absorption, compassion, and responsive action will become spread so thin as to dilute popular outrage and forestall responsive action. Today, as I address engineers, data scientists, and future harbingers of technological innovation amongst you, I'm excited to see the strides that our society makes as a result of your contribution. However, I must warn you that it is important that steps towards improving artificial intelligence, automation, and digitization must be mindful of the ways in which it would alter our social and economic relations. This brings me to the third kind of price we often pay. In his book titled To Save Everything, Click Here, Evgeny Morozov critiques what he calls solutionism, the idea that given the right code, algorithms and robots, technology can solve all of humankind's problems, effectively making life frictionless and trouble-free. Techno-solutionism is problematic because its roots run deep and it is incredibly hard to weed from public discourse once it has been introduced. At its core, the issue with techno-solutionism is that it assumes that all ills can be cured by the right technology. In doing so, it ignores that economic, cultural, social, racial, classist, and casteist problems which plague our society. I do not say this to suggest that technological solutions should not be sought to issues of governance. Rather, I emphasize that their limitations in changing the mindset of society should be acknowledged. Some of these technological solutions may suffer from the same ills that plague society because they are ultimately a byproduct of society itself. For instance, while we think that algorithms are the key to the future, they can just as easily become gatekeepers of opportunity, deciding critical things such as who gets a job or quality of healthcare and what communities get undue police scrutiny. A recent Netflix documentary called Coded Bias followed the work of Joy Bolamwini, whose research exposed that facial recognition algorithms did not recognize the faces of Black women as human beings. The input images on which the various facial recognition algorithms were based consisted 80% of images of white persons and 75% of images of male faces. As a result, the algorithms have a high accuracy of 99% while detecting male faces. However, the system's ability to recognize the faces of Black women was significantly lower at only 65%. Facial recognition algorithms may serve as a form of policing and can be misused for surveillance. Hence, a combination of these ethical and policy concerns must be critical considerations for guiding innovation. Similarly, we know that data is a key ingredient that makes machine learning possible. However, not all data is created equal, nor is it equally available across geographies and demographics. The biggest sources of risk for data-related discrimination are inadequate data availability and biased or error-ridden data. Therefore, diversity in the data set becomes key to protecting human rights. Caroline Criado Perez, the author of the book Invisible Women, in which she investigates the absence of gender from data and its impact, has explained that if artificial intelligence is based on bad data, sourced predominantly from men and or based on male profiles, it can have several unintended consequences. She speaks of examples as basic as seat belts in cars or the airplane, headrests, and airbags in cars. In her research, she found how their designs are predominantly based on data collected from car crash dummy tests using the physique of men and their seating position. On the other hand, women's breasts and pregnant bodies don't feed into these seemingly standard measurements. As a result, women are 47% more likely to be seriously injured and 17% more likely to die than a man in a similar accident. In today's world, the common perception is that raising concerns about these issues within the world of technology will kill innovation. The truth is quite the opposite. I believe that regulation, coupled with innovation, can result in marvels in society. Technology should be designed not with the solitary aim of efficiency, but to serve the inherent value of every human being. An example of a potential solution to ensure that artificial intelligence is responsive to gender considerations and other ethical considerations is the application of certification processes. Commercial considerations may overlook societal discrimination and caste, class, and gender-based marginalization. Solutions such as obtaining an AI certification in certain regions across the world have been introduced to further distinguish companies and better position them in the investor and consumer markets. Denmark has just launched the prototype of a data ethics seal, which is backed by Danish companies who view the seal as an opportunity to gain a competitive advantage. Another interesting example of the way in which the law can fundamentally alter the inbuilt design of technology comes from the European Union's data protection law, called the General Data Protection Regulation. The law requires privacy by design, which means that companies must design products and services with a default assumption that they protect privacy, data, and information of data subjects. It forces corporations to consider not just new products and services, but also the essence of their processes and take stock of whether they are privacy friendly and privacy centric. A robust system of enforcement has established the EU as a model jurisdiction for data privacy and regulation. Scholars have argued that the future lies in the push for a human rights by design principle, where the scientific community commits to designing tools, technologies, and services to respect human rights by default, rather than permit abuse or exploitation as part of their business model. This would, for example, prevent filtering companies from designing their technology with features that enable large-scale, indiscriminate, or inherently disproportionate censorship capabilities, like the net sweeper feature that allows an internet service provider, colloquially called an ISP, to block an entire country's top-level domains. NetSweeper, for the uninitiated, is a technology company that provides online filtering services to ISPs across the world. Choices made by NetSweeper have had a significant impact on the types of websites that users in a given country can ultimately access. NetSweeper's technology facilitates the blocking of digital speech. While it is important to improve the design of our technological solutions in envisaging a free and accessible digital sphere, it is equally crucial for us to reflect on the platform economy that has replaced traditional modes of employment. With the introduction of several mobile or web-based apps, the labor market has fissured, and the gig economy has had significant ramifications on existing business models for food, clothing, and groceries. App-based companies have alleged immunity from labor law obligations because these platforms are legally structured as aggregators and intermediaries. Their contract-based relationship with app-based workers does not fit in within traditional definitions of employment, and the disaggregated nature of app-based work makes collective bargaining with platforms difficult. As a result, traditional labor law in India, which exists as a dispersed set of statutes, has not been effectively applied to most platforms. How, for instance, does the labor law requirements of maintaining a creche or a statutory canteen or providing wages for overtime work translate in the emerging world of digital spaces? These vexed issues are important for consideration across the domains of law, regulation, technology, and policy. Hence, a distinct blueprint of legal measures to effectively improve the conditions of app-based workers is urgently required. It is imperative that interventions cater to the distinct nature of app-based work, including ensuring autonomy for workers through increased transparency regarding fees earned and the ability to choose work. At the same time, it should clarify minimum obligations of platforms towards enhancing worker welfare, especially concerning health, safety, and skill development. Our world today has been transformed by technology, and we are living in the digital age where data and information are the new oil. Intellectual property law is currently in the process of catching up and will soon have to remold itself to achieve its aim of maximizing human potential. Lawrence Lessig, a prominent scholar on the information age, has noted that the internet has unleashed an extraordinary possibility for many to participate in the process of building and cultivating a culture that reaches far beyond local boundaries, creating the possibility of markets that include a much wider and more diverse range of creators, if not stifled by incumbents who use intellectual property law to protect themselves against this competition. To conclude, I would like to recount an interesting reference from Ari Ezra Waldman's book, Industry Unbound, the inside story of privacy, data, and corporate power. Ari wrote this book on informational privacy law after nearly 4 years of field work in technology companies. He had gone to the office of one such company to speak to its employees. He had caught up with a software engineer who had stepped out of a meeting. This person was a part of a team that was building a photo sharing app. After a couple of questions about the project, including its interaction with Instagram, Ari asked, when programs have to talk to each other, are there privacy issues you have to deal with? The software engineer quickly replied, that's really for someone else to do. I don't know. It gets done, I'm sure, but I don't know it. This is striking because here is this person who is working on an app involving copious amounts of data that includes the faces of the user, their friends, their family, their children. Questions of privacy were hardly an issue or a consideration while designing the code. This is concerning because the people who are at the front line of protecting our privacy and human rights in the digital space do not necessarily sit in law schools, courtrooms, or even parliaments, but right in this room. The real power over the implementation of digital rights rests with technology companies generally, and with engineers and designers in particular. In effect, you are involved in translating human rights law into real life. Effectively, you are not just coding, you're invisibly rewriting the rules of our society, the menus from which our lives are being chosen. After all, in cyberspace, code is law. And with this power comes the responsibility to interrogate the codes that are coming out into the products. This is where thinking about the law and power relations within society can help you specifically as the architects of our digital world. In this era of technology revolution, it is my earnest hope that the legal system, in dialogue with the scientific community, is able to address these concerns and to democratize these spaces. I thank you very much for this gracious invitation, and I'm deeply honored to honor the memory of Justice PM Mukhi. Thank you very much.
Thank you so much, Dhananjay. That was a really informative and insightful talk. I think all of us will have plenty to mull over later on as we think about all the issues you brought up. So on behalf of the audience of this talk who joined, I'd like to thank everyone. It is nice to have an informal discussion, but we feel that informal discussions with the speaker are best had in person. And I'd like to invite Dhananjay to please visit ISER Pune sometime later on and to interact with us. And for now, let me thank him, first of all, and all of you, members of the family, friends, associates, colleagues who have joined for this evening. Thank you very much. We end here.
Thank you.